Lost your gun rights after a felony conviction? You might think they're gone forever, but here's what most people don't know. There are 8 legal pathways to restore your Second Amendment rights, and one of them just became available again in 2026 after being shut down for decades. The Department of Justice relaunched the Federal Gun Rights Restoration Program this year, and it's already expected to receive over 1 million applications. This changes everything for nonviolent felons. Today, I'm breaking down all 8 methods, from state expungement to presidential pardons, so you know exactly which path works for your situation. Some of these restore your rights automatically after a waiting period. Others require court petitions or clemency applications. But here's the critical part. Not everyone qualifies. Certain convictions create permanent federal prohibitions, and I'll show you exactly which ones at the end of this video. Let's get into it. Method 1. Felony expungement. Expungement is the gold standard for gun rights restoration because it removes or sets aside your felony conviction from your criminal record entirely. When your record is expunged, it's like the conviction never happened, and that includes restoring your firearm rights. But here's the catch. Expungement laws vary dramatically by state, and not all states offer it. Oregon has one of the most comprehensive expungement systems under ORS 137.225. If you were convicted of a non-homicide, non-weapons felony, you can petition for expungement after 15 years from the date your sentence was completed, including probation and parole. Once granted, your gun rights are fully restored under both state and federal law. North Carolina allows expungement for Class H or I nonviolent felonies after a 10-year waiting period. The key requirement? You must have no other felony convictions during that decade, and you can't have any pending charges. California uses a different system. Under Penal Code 17b, you can petition to reduce certain wobbler felonies to misdemeanors. Once reduced, you're no longer prohibited under federal law from possessing firearms. California also offers certificates of rehabilitation, though these don't automatically restore gun rights. They serve as applications for a governor's pardon. Here's what you need to know. Expungement doesn't work in every state. Some states like New Jersey don't offer expungement for most felonies. Others limit it to specific offense categories. And even if your state grants expungement, you must verify that it removes the federal firearm prohibition under 18 U.S.C. 922G. Some state expungements only restore state-level rights, leaving the federal ban in place. Research your state's expungement statutes. Look for language that explicitly states all civil rights are restored or firearm rights are restored. If you're unsure, consult an attorney who specializes in gun rights restoration in your jurisdiction. Method 2. Petition for restoration of firearm rights. Many states allow you to petition a court directly for restoration of your firearm rights without requiring a full pardon or expungement. This is often faster and more accessible than going through the governor's clemency process. Ohio has a robust petition system under ORC 2923.14. If you're a nonviolent felon who has completed your sentence, probation, and parole, you can file a petition in the county where you were convicted. The court will review your case and can grant relief from the firearm disability if you meet these requirements. No disqualifying factors like domestic violence convictions. No mental health adjudications. Outstanding restitution or victim compensation disqualifies you immediately. The process goes through Florida's Office of Executive Clemency. After you submit your application, an investigation is conducted. Then your case goes before the Clemency Board, which consists of the governor and the entire cabinet. You need unanimous approval from all members. In recent years, Florida has granted fewer than 5% of firearm rights restoration applications. Texas has a different system. A governor's pardon can restore your gun rights, but you must file a separate application specifically requesting firearm rights restoration. A general pardon doesn't automatically restore gun rights in Texas. You must explicitly ask for it in your clemency petition. California uses a 2-step process. First, you apply for a certificate of rehabilitation through the Superior Court in the county where you reside. This certificate serves as your automatic application for a governor's pardon. The governor's office reviews these applications, but approval rates are extremely low, typically under 10%. New Jersey only allows gun rights restoration through a governor's pardon. There's no certificate of rehabilitation or direct court petition available. This makes New Jersey one of the most restrictive states for restoration. Here's what you need to understand about pardons. They're discretionary political acts. Governors consider public safety, political implications, victim input, and media scrutiny. High-profile cases or violent offenses face significantly lower approval odds. The waiting periods vary by state. Florida, 8 years. Louisiana, 10 years. New Mexico, 10 years. Oklahoma, varies by offense severity. Documentation requirements are extensive. You'll need certified copies of all court records, proof of completed sentencing, letters of recommendation from employers, clergy, community leaders, evidence of rehabilitation, employment records, education certificates, community service, victim impact statements, if applicable, personal statement explaining why restoration serves public interest. Visit your state's clemency or pardon board website. Download the application packet and review eligibility requirements. Start gathering documentation now. The process can take 2 to 5 years from application to decision. Method 4. Presidential pardon. If you were convicted of a federal felony, your path to restoration goes through the President of the United States, and it's the rarest and most difficult method on this list. Presidential pardons are granted by the Office of the Pardon Attorney within the Department of Justice. The process is highly selective. In recent administrations, presidents have granted fewer than 100 pardons per year out of thousands of applications. Here's what makes presidential pardons unique. They can restore federal firearm rights, but they do not automatically restore state-level rights. If you have both federal and state convictions, you'll need restoration at both levels. The application process requires at least 5 years since completion of your sentence, detailed personal statement, multiple character references, FBI background check, financial disclosure, explanation of how the conviction has impacted your life. Unless you have significant political connections, legal representation from a high-profile attorney, or an extraordinarily compelling case, presidential pardons are statistically unlikely. Most successful applicants have served decades since their conviction and demonstrated exceptional rehabilitation. When to consider this path, if you were convicted of a non-violent federal offense, like a white-collar crime or regulatory violation, served your time, and have maintained a spotless record for 10+ years, you might have a viable case. But you'll need experienced legal counsel who specializes in federal clemency applications. If you have a federal conviction, review the Office of the Pardon Attorney's website for current application procedures. Be prepared for a multi-year process with no guarantee of success. Method 5. Automatic restoration after sentence completion. This is the method most people don't know exists. In certain states, your gun rights are restored automatically after you complete your sentence and wait a specified period. No petition, no pardon, no court hearing required. Michigan leads the pack here. For most felonies, Michigan restores gun rights automatically after a set period following sentence completion. The waiting period depends on your offense classification, but for many nonviolent felonies, it's 3 to 5 years after you finish probation and parole. Texas has a unique split system. After 5 years from release for a felony conviction, you can possess firearms in your home only. But full restoration, including carrying outside your home, requires either a pardon or a court order. Here's the important part. Non-domestic violence misdemeanors in Texas restore automatically upon sentence completion, including probation and parole. Utah allows automatic restoration after 10 years post-discharge for certain felonies, but violent felonies and domestic violence convictions are permanently excluded. Arizona automatically restores gun rights for non-violent felonies after sentence completion, but violent felonies and domestic violence offenses remain permanently disqualified unless you obtain a gubernatorial pardon that explicitly states firearm rights are restored. Here's the critical distinction. Sentence completion means everything. That includes prison time served, probation completed, parole completed, all fines paid, all restitution paid, all court costs satisfied. If you still owe $1 in restitution, your sentence is not complete, and the waiting period hasn't started. Federal law complication. Even if your state automatically restores your rights, federal law under 18 U.S.C. 922(g) may still prohibit you from possessing firearms unless the state restoration meets federal criteria. The state must restore all civil rights for federal law to recognize it. Now, how to verify your status. First, contact your state's Bureau of Criminal Investigation or equivalent agency. Second, request a firearm eligibility determination. Third, provide certified copies of your conviction and sentencing documents. Fourth, get written confirmation of your restoration status. If you live in a state with automatic restoration, calculate your eligibility date based on when you completed all aspects of your sentence. Then request official verification from your state before attempting to purchase or possess firearms. Here's a huge mistake people make. They assume that if their state says, "You're good," then the feds automatically agree. Not always. You must be legal under state law and federal law. If either one still prohibits you, you cannot legally possess a firearm. That's why, before you touch a gun, you want written confirmation of your status, not just what a clerk told you on the phone. Now let's go to method number 6, which is especially important in states with wobbler offenses. Method 6, reduction/set-aside of felony. In some states, certain crimes can be charged either as a felony or as a misdemeanor. These are often called wobblers. If you were convicted of a wobbler felony, you may be able to ask the court to reclassify it as a misdemeanor, and in some states, that change can remove the federal firearm prohibition. For example, purely as patterns, not advice for your specific state. Some states allow post-conviction motions under statutes similar to 17b style provisions, asking the judge to reduce the felony to a misdemeanor and then dismiss it or set it aside after probation is completed. Other states have set-aside laws. The conviction is not erased, but it's marked as set aside or deferred. In a few states, that's enough to restore firearm rights. In others, it helps you qualify for another process, like a pardon or rights restoration petition. Federal law generally looks at whether you were convicted of a crime punishable by more than 1 year. If your offense is properly reduced so that it is no longer punishable by more than a year, the federal ban may no longer apply. Key questions to ask a local attorney. Was my offense a wobbler under my state law? Can it still be reduced, even years later? If reduced, does that restore my state gun rights? Remove the federal 922G prohibition. Pull your original judgment, charging document, and statute number. When you talk to a lawyer, you want to say, "I was convicted under statute. Is this a wobbler? And is there a process to reclassify it as a misdemeanor and restore firearm rights?" Method 7. Relief from mental health-based prohibitions. Not everyone lost their rights because of a criminal conviction. Some people are prohibited because of a mental health adjudication. This includes situations like court-ordered involuntary commitment or being found mentally incompetent in a legal proceeding. Federal law treats these as separate disqualifiers from felonies. The good news is that many states now have a relief from disabilities process specifically for mental health-based firearm bans. Common features vary by state, but typically you file a petition in the same court that ordered the commitment or with a designated state board. You will need to provide medical records, letters from your current treating doctor or therapist, and proof of stability such as employment, housing, and community support. The court or board must find that you're not likely to act dangerously and that granting relief is in the interest of public safety. If granted, the state then reports that relief to the federal background check system called NICS, which can lift the federal mental health firearm prohibition. Important distinctions to understand. This is usually not about erasing the past. It's about proving your current stability. Standards can be strict, and judges will often err on the side of caution. You almost always need very solid medical evidence. To get started, call the clerk of the court where the mental health order was issued and ask whether your state has a relief from firearm disabilities process for mental health commitments, and where you can find the forms or statute number. Then talk with a local attorney who handles both firearm law and mental health law. Method 8. Civil rights restoration and relocation. This last method is more strategic and long-term. Federal law looks very closely at whether a person's civil rights have been restored, including the right to vote, the right to serve on a jury, the right to hold public office. In some states, when those civil rights are fully restored by law or by court order, and the law does not specifically say, but you still can't have guns, that restoration can help remove the federal firearm disability. Sometimes, this happens. You're convicted in State A. You serve your sentence and later have your civil rights restored there. You move to State B, which has more favorable firearm laws. If both State A has truly restored your civil rights and State B does not add an extra prohibition, then you may be able to legally possess firearms in State B under both state and federal law. But this is high risk to guess on your own. Why? If you misunderstand either state's law or the federal standard, you can be charged with felon in possession, which carries serious prison time. Get a certified copy of any civil rights restoration order or notice from the original state. Then, before moving or buying a gun, Consult an attorney in the state that convicted you and an attorney in the state you plan to live in. Ask them both the same question. Given my conviction under statute and this civil rights restoration document, am I prohibited from possessing firearms under federal law and under your state law? A quick lightning round of things that do not restore your gun rights. Buying a gun for protection only. Intent doesn't matter. The law does. Having your spouse or friend buy and own the gun while you use it. Internet felony removal services that don't ask what state you're in, don't talk about specific statutes, promise a 100% guaranteed clean record for a flat fee. Just moving to a gun-friendly state. Verbal statements from a clerk, probation officer, or even a police officer. If you're prosecuted, but they told me it was okay, is rarely a defense. If there is no court order, no statute, and no official restoration process backing you up, assume your prohibition is still in effect. Before you try to buy, own, or even touch a firearm after a felony conviction, you want to have a clear understanding of your original charge, the exact statute number, whether it's considered violent, domestic, or weapons-related. Documentation, judgment, and sentencing paperwork. Proof you completed every part of the sentence, fines, and restitution, any expungement, set-aside, pardon, or rights restoration orders. Written confirmation from a qualified attorney in your state, and, ideally, an official eligibility check from the relevant state agency. This is education, not legal advice. Your exact options depend on your state, your specific conviction, your full criminal and mental health history. Laws change constantly, and what's true in one state today might not be true next year. If you want a follow-up video where I break down state-by-state examples or walk through real restoration paperwork line by line, tell me in the comments. What state are you in, and what kind of conviction are we talking about? Also, check the links in the description where I'll include statute keywords to research in your state, a checklist you can print and take to your attorney. If you found this helpful, tap like so YouTube knows to show this to more people who need it. Subscribe for more clear gun law breakdowns, and watch this video right here next for a deeper dive on prohibited person laws.